how to slay the third-headed beast, financial creditors and predators, and the second-headed beast, the tax man. Oh my. Oh, hey folks, elder law care attorney Patrick Kelleher. Folks, today's question is, should I put my children's names on my assets, or should I transfer my assets to my children while I'm still living? Folks, pull up a chair, get your pen and notebook out, because today we're going to answer that question. So folks, typically it's not a great idea. From my experience, the disadvantages strongly outweigh any advantages of that type of planning. And I created a simple acronym for you to write down in your notebook called the 3 T's. The 3 T's, okay? Or the 3 troubles or the 3 terribles, okay? So number one, from my experience, the first T would be taxes, the terrible taxes or the trouble with taxes, okay? So if you transfer your property, say you put your children's name on your deed to your home, well, you're giving them your carryover basis, which is tax talk for the original price you paid for your home maybe 30, 40 plus years ago, okay? So think about that. And after you pass away, your child, if they're on the deed to your home, yes, you'll avoid probate court, but now your child is going to get bit hard by the tax man for capital gains tax, because when you made that lifetime gift to them, okay, they took on your carryover basis or your original cost of what you paid for that house 30, 40, 50 years ago. So now your child sells that property after you're gone. Say, for example, your purchase price of the house was $30,000 many years ago. Your child's going to take on that $30,000 basis as their starting point. Now, after you pass away, they sell the house for $530,000. They have a $500,000 capital gain that they're going to have to pay capital gains tax on at the rate of about 20%. So when you subtract the sale price in the future, $530,000, minus their original carryover basis, because you gave them that lifetime gift, 30 minus 530 is what? 500,000, simple math, times the capital gains tax rate of about 20%. It's usually 15% federal, 5% state. So 500 times 20 is what? Get the calculators out. $100,000 capital gains tax bill for your child. Do you think they'll be happy? No. So that is not a wise thing to do, putting your children's names on the property. Okay, second reason is if you put your child's name on your bank accounts, yes, again, you'll avoid probate court. But guess what? Here in the Commonwealth of Massachusetts, the tax man cometh again, the second-headed monster. More trouble, more terrible scenarios. You put your child on your investment account, your bank account to avoid probate court. All well and good, right? But when you pass away here in the Commonwealth, if you have an estate greater than $1 million under current law, then you're going to owe estate tax to the Commonwealth. $1 over $1 million is about 18 grand owed. $1.5 million estate is about $64,000 owed. But some folks think, well, I'm going to put my child or children's names on my account with me, and that way the taxing authority will only value half of my assets into my estate for the estate death tax. Not so, folks. That's practical thinking, but not all the tax laws are practical thinking in nature for the consumer. So the taxing authority has themselves covered under that scenario. So even their view, their regulation is the following. Even if an individual who passed away put their children on their bank accounts or investment account or whatever it may be, and that account is held jointly. Say it's a $500,000 account. The full $500,000 will be added and valued into your gross estate for the estate death tax, okay? Because the taxing authority will assume that the co-owner made no contributions to the value of that account, unless they can prove with an affidavit otherwise, which from my experience is usually not the case. Then the full amount would still be taxed into your gross estate for the estate death tax, okay? So we talked about 2 types of taxes here, capital gains tax, the first T, and we're talking now about the estate death tax. The other T, or the other terrible, from my experience, would be if you transfer any assets to your children, whether it's the home, any cash accounts, you're making a transfer. And my concern, most folks from my experience are making these transfers later in life. And if you make a transfer within 5 years of ever needing Medicaid benefits in a nursing home, you're creating what they call a penalty period. You're creating an impermissible transfer because the date that you fill out that Medicaid application and you ask Medicaid or Mass Health to help supplement and pay some of your nursing home cost, Medicaid caseworker has the right to look at the date of application, looking back, the 5-year look back period, looking back at 5 years of your finances and your transfers. So if you make a transfer, a gift, put your child on your home, put your child on a bank account or any other asset for that matter, and then within 5 years, if you become completely incapacitated and you're looking to apply for Medicaid benefits and ask Medicaid to pay for your skilled nursing facility, Medicaid is going to say no. They're going to pull out their denial stamp and said you made an impermissible transfer. They're going to create what they call a penalty period. And then the only way, or one of the common ways to cure that penalty, your child should be paying back that money to you. In the real world, typically not often done because a child may not have that money any longer. So that's a second disadvantage to adding children to your property, the transfer penalty rules. The third T, from my experience, is transferring, you're losing control. I'm going to use the possible threat of losing your home if your child is on your home and if your child is married. And what about if your child is now going through a contentious divorce and they're on your home or any other asset for that matter, and now the in-law is turning into an outlaw? We call that the third-headed monster, financial creditors and predators. Now you're at risk or the threat of losing maybe half of your asset or potentially all of it in a situation if you transferred the entire asset to your child. So that's the threat and risk of losing control and maybe losing possession and ownership of your asset altogether. So folks, from my experience, the disadvantages highly outweigh the advantages of maybe mere probate avoidance when you're transferring property to an adult child. Folks, if you'd like to learn more, I do have another video on this as well. Check it out, other 3 disadvantages of transferring your property to your children. If you found this video helpful, please scroll down, post a comment, post a question, because a member of our Elder Law Care team will get back to you as soon as possible. If you'd like to further your education in this area, recommend pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, or simply go to elderlawcare.com where you can learn more and pick up a copy of the book there as well. Folks, thanks for joining us here today at elderlawcare.com.